A courtroom on the edge. Silence fell over the courtroom like a storm about to break. It wasn't the ordinary quiet of legal proceedings. It was the kind of silence that carries weight, the kind that makes every cough sound too loud and every shuffle of paper feel amplified. Outside, cameras lined the courthouse steps. Reporters rehearsed their live intros. Producers checked microphones. Everyone sensed that something significant was about to unfold. Inside, the gallery was packed. Lawyers filled the front rows, legal observers sat with notebooks ready, and members of the public leaned forward in their seats. What had been scheduled as a routine legal hearing had transformed into something much bigger, a confrontation over power, authority, and the limits of the American legal system. At the center of it all stood Pam Bondi. She carried herself with calm precision. Her posture was straight, her expression steady. There was no visible frustration, no outward sign of nerves. But make no mistake, she had come prepared for a fight. Bondi wasn't there to apologize. She wasn't there to soften her stance. She was there to challenge what she believed was a court stepping beyond its constitutional boundaries. And when she began to speak, the entire energy of the room shifted. Her voice was firm, measured, and deliberate. Every sentence sounded carefully chosen. She argued that the court's recent directive went too far, that it crossed the line between interpreting the law and actively shaping policy. In her view, that line matters deeply. This court does not have unlimited authority, she stated clearly, looking directly at the bench. The words hung in the air. Challenging a court's authority is no small move. Courtrooms operate on structure, respect, and precedent. Judges are granted significant power for a reason, to interpret the law impartially and ensure it is followed. But Bondi's argument centered on a key principle. Courts must also know their limits. She suggested that when a judge's order begins to dictate how elected officials carry out their responsibilities, the balance of power begins to tilt. And that balance, the separation between branches of government, is foundational to the system itself. The judge listened without interrupting at first, his expression composed but unmistakably stern. His hands were folded on the bench, his gaze fixed steadily on Bondi. The courtroom could feel the tension building like static electricity. When he finally leaned forward, the shift was subtle, but noticeable. He began asking pointed questions. Wasn't the matter properly before the court?
Didn't precedent give the judiciary the authority to intervene in certain circumstances? Wasn't the court obligated to act if it believed the law required enforcement? Each question sharpened the exchange. Bondi responded without hesitation. She cited constitutional principles, referenced prior rulings, and emphasized the importance of judicial restraint. According to her, courts are not policymakers. They are interpreters. And when interpretation turns into direction, the lines begin to blur. The judge's tone grew firmer. He reminded everyone in the room that the judiciary's role is not symbolic. It is binding. Once a case is brought before the court and a ruling is issued, compliance is not optional. The integrity of the system depends on it. For a brief moment, neither side spoke. The silence returned, thicker than before. This was no longer a routine procedural debate. It had evolved into a high-stakes exchange about institutional power. The tension wasn't personal. It was structural. Two interpretations of authority were colliding head-on. Observers in the gallery exchanged glances. Some scribbled notes quickly. Others simply watched, wide-eyed. Even seasoned legal professionals understood that moments like this are rare, when a courtroom becomes a stage for deeper constitutional questions. Bondi stood her ground. She clarified that challenging the court's interpretation did not mean disrespecting the judiciary. Instead, she framed her stance as a defense of the constitutional framework itself. Healthy tension between branches, she implied, is not a flaw. It is a feature. But the judge made one thing unmistakably clear. Disagreement does not permit disregard. His voice carried a new edge as he explained that failure to comply with a lawful order could lead to consequences. The authority of the court, he emphasized, must remain intact. Without enforcement power, rulings become suggestions, and the legal system cannot function on suggestions. The warning was subtle, but it was there. The atmosphere shifted yet again. This was the turning point, the moment where legal theory met practical reality. Would this remain a debate inside the system, or would it escalate into something more confrontational? Cameras outside continued rolling.
News alerts were already being drafted. Social media buzzed with speculation about what might happen next. Inside the courtroom, though, it was intensely human. Two sides, two interpretations, one legal system. Bondi adjusted her papers slightly, her expression unchanged. She knew the significance of the moment. Challenging a judge's authority carries risks, political, legal, and public.
But retreating without argument would mean conceding a principle she clearly believed mattered. The judge leaned back in his chair, studying the room. The message from both sides was unmistakable. This was bigger than a single order. It was about defining the boundaries of power, about who decides where authority begins and ends. And as the hearing continued, one thing became crystal clear. This courtroom was no longer just a place for legal procedure. It had become a battleground for the meaning of authority itself. Drawing a line in the sand. The issue at hand hadn't appeared overnight. It had been building quietly for weeks, maybe even longer. Legal motions had moved back and forth like chess pieces. One filing led to another. Orders were issued. Objections were filed. Responses were drafted deep into the night. On paper, it looked like a typical high-profile legal dispute. Complex, technical, procedural. But this hearing was different. This was the moment where arguments would no longer live inside documents. They would be spoken out loud, in open court, under the weight of public attention. At the center of the challenge stood Pam Bondi, calm, focused, and clearly ready to make her stand. When she rose to speak, there was no rush in her movement. She organized her notes carefully, adjusted the microphone slightly, and began in a steady, deliberate tone. Her argument was clear from the start. The court's recent directive, in her view, had gone too far. According to Bondi, the judge had crossed a constitutional line, moving from interpreting the law into effectively shaping policy. And that distinction, she argued, was not minor. It was fundamental. In the American system of government, powers are divided. Legislators create laws, executives enforce them, courts interpret them. Each branch has its lane. Each branch has its limits. Bondi's position was that this court had drifted out of its lane. This court does not have the authority to mandate this action, she stated firmly. The words landed heavily in the room. Challenging a specific ruling is common in court, but challenging the scope of a judge's authority, that is something else entirely. It's a move that requires confidence and carries risk. As she continued, Bondi laid out her reasoning step by step. She referenced prior cases, constitutional principles, and the importance of maintaining boundaries between branches of government. Her voice never rose. She didn't need it to. The seriousness of her argument spoke for itself. She explained that when courts begin issuing directives that resemble policy decisions, they risk stepping into territory reserved for elected leaders, people chosen by voters to make those calls. If that boundary erodes, she warned, it shifts power away from democratic accountability. The tension in the courtroom began to build. The judge leaned forward, elbows resting lightly on the bench. He listened carefully, occasionally jotting down notes, but soon he began to interject. His questions were sharp and precise. Wasn't the court responsible for ensuring compliance with the law? If a dispute is brought before the judiciary, doesn't it have the authority to resolve it fully? And if resolving it requires specific instructions, how is that overreach? His tone remained controlled, professional, but unmistakably firm. He reminded everyone present that courts exist precisely because conflicts over law and authority arise. When branches of government disagree, it is often the judiciary that must step in and provide clarity. Authority, he implied, cannot be selective. Bondi listened carefully to each question before responding. She did not interrupt. She did not appear rattled. But she didn't retreat either. Instead, she doubled down. Judicial power, she argued, is strongest when it is exercised with restraint. The legitimacy of the court depends not only on what it can do, but on what it chooses not to do. If courts overextend, she warned, it creates a precedent that shifts policymaking into the hands of unelected officials. The phrase unelected officials echoed in the room. It wasn't an attack. It was a principle. Her argument wasn't that courts lack authority altogether. It was that authority must have boundaries. Without limits, even well-intentioned rulings could slowly reshape the balance of power in ways the Constitution never intended. The exchange grew more intense, not louder, but sharper. The judge emphasized that once a matter is properly before the court, it cannot simply issue vague guidance. It must issue enforceable decisions. Otherwise,
Its role becomes symbolic rather than functional. Bondi countered that enforceable decisions must still remain within constitutional limits. Enforcement does not justify expansion. Back and forth it went, measured, deliberate, unwavering. Observers in the gallery could feel that this was no longer just about compliance with one directive. It had evolved into a broader debate about philosophy, about how power should be distributed and constrained. The courtroom had transformed. It was no longer just a legal space filled with statutes and citations.
It had become a philosophical battleground, a live demonstration of checks and balances in action. On one side stood the principle of judicial authority, the idea that courts must have the power to interpret and enforce the law decisively. On the other stood the principle of judicial restraint, the belief that courts must guard against stepping into roles reserved for elected branches. Neither side appeared willing to surrender their ground. And that's what made the moment so powerful. This wasn't chaos. It wasn't disrespect. It was democracy under pressure, institutions testing their boundaries in real time. As the arguments continued, the air in the room felt heavier. Everyone understood what was at stake. If the judge ruled firmly in one direction, it would reinforce the strength of judicial intervention. If Bondi's challenge gained traction, it could narrow how far courts are willing to go in similar cases moving forward. A line had been drawn in the sand, and neither side was pretending it wasn't there. The only question now was who would step back, or whether that line would become the starting point of an even larger legal battle. The judge responds. When the judge finally began to speak at length, the transformation in the courtroom was immediate. The low murmurs stopped. Pens paused mid-sentence. Even the subtle rustling of papers seemed to fade. Every eye turned toward the bench. He didn't rush his words. At first, his tone was calm, almost reflective. He acknowledged the arguments presented by Pam Bondi. He admitted that questions surrounding judicial reach and constitutional boundaries are not simple. In fact, he recognized that debates over the limits of court authority have shaped American legal history for generations. Reasonable minds can disagree, he said, glancing briefly at the attorneys before him. It sounded, for a moment, like a bridge between positions. But then his expression hardened slightly. His voice grew firmer. The authority of this court, he stated clearly, is not optional. The sentence cut through the room. He leaned forward, hands resting firmly on the bench, and began outlining his reasoning. When a matter is properly brought before the court, he explained, the judge does not have the luxury of inaction. It is not merely a power granted to him, it is a responsibility assigned by law. Courts exist to resolve disputes, and resolution, he emphasized, requires enforceable decisions. Without that enforcement power, the judiciary would become symbolic, issuing opinions that carry no real weight. And that, he warned, would weaken the entire structure of the legal system. He described the judiciary as a pillar. Remove its authority, and the balance of government begins to tilt. Ignore its rulings, and the rule of law itself begins to erode. His words were measured, but they carried unmistakable force. Ignoring or undermining a lawful court order, he continued, is not an act of principled disagreement. It is a challenge to the system itself. The tension in the courtroom shifted from philosophical to personal. This was no longer a debate about theory. It was about compliance. Bondi stood still, her posture unchanged. Her expression remained composed, but those watching closely could sense the gravity of the moment. The stakes had just risen. The judge made it clear that disagreement is part of the legal process. Appeals exist. Motions exist. Higher courts exist. The system provides pathways for challenging rulings. But those challenges must occur within the framework of the system, not outside it. And then came the warning. If the court's directive was not followed, he said, he would consider additional enforcement measures. The phrase hung in the air like a thundercloud. He did not raise his voice. He didn't need to. Additional enforcement measures could mean sanctions, financial penalties designed to compel compliance. It could mean contempt findings, formal declarations that someone has disobeyed the court. In extreme circumstances, it could mean escalated legal consequences that draw even more public attention. Each possibility carried weight. The judge didn't specify which option he would choose. He didn't need to. The message was clear enough. The authority of the court would be defended. You could almost feel the room holding its breath. Reporters in the gallery exchanged quick glances.
Legal analysts scribbled notes rapidly. This was the turning point everyone had anticipated. The moment when abstract arguments collided with real consequences. Bondi did not interrupt. She did not object. She listened. And in that stillness, the gravity of the situation became unmistakable. This was no longer simply about whether a directive had crossed a constitutional line. It was about whether that directive would be followed. The judge continued, explaining that the judiciary does not operate on personal preference or political motivation. It operates on law. When courts begin issuing orders, they do so under the authority granted to them by the Constitution and by statute. To disregard those orders, he suggested, would send a dangerous signal that compliance is conditional. And conditional compliance is not compliance at all. His final words carried a sharp clarity. Disagreement is allowed.
Defiance is not. The distinction mattered. The courtroom felt charged, almost electric. No one shifted in their seat. No one whispered. For a brief moment, time seemed suspended. Bondi stood firm, but even the most neutral observers could see that the dynamics had changed. The judge had drawn a line, not just philosophically, but procedurally. If the directive stood and was ignored, consequences would follow. The confrontation had reached a crossroads. Would this escalate into a direct clash between a public official and the judiciary? Or would the disagreement move into the appeals process, where higher courts could weigh in? The judge leaned back slightly, signaling that his statement was complete, at least for now. The silence that followed was heavier than any raised voice could have been. In that silence, the central question shifted. It was no longer simply about who had the stronger legal theory. It was about who would yield, and how far each side was willing to go to defend their interpretation of authority. The next move would determine everything. And everyone in that courtroom knew it. Power, principle, and public reaction. Outside the courthouse, the silence of the courtroom was replaced with pure noise. Cameras flashed, microphones were thrust forward. Reporters spoke urgently into live broadcasts. Within minutes, headlines were spreading across television screens and social media feeds. What had happened inside that courtroom was no longer confined to legal professionals. It had become a national conversation. Supporters of Pam Bondi wasted no time voicing their approval. To them, Bondi wasn't defying the law. She was defending it. They argued that her stance represented a necessary stand against what they saw as judicial overreach. In their view, courts are meant to interpret laws, not expand their influence into areas reserved for elected officials. Many framed the moment as a defense of executive authority. They believed that if courts begin directing how policies must be carried out, they risk stepping into the role of policymakers, a role assigned to individuals chosen by voters. On social media, hashtags began trending. Supporters described her as standing her ground and protecting constitutional balance. Commentators sympathetic to her argument emphasized the importance of maintaining clear boundaries between branches of government. But the reaction was far from one-sided. Critics responded just as quickly and just as passionately. To them, the issue was not about overreach, but about respect for the rule of law. They argued that once a judge issues a lawful order, compliance is not optional. Challenging that authority publicly, they warned, could undermine public confidence in the legal system. Legal compliance, they said, is the backbone of democracy. If officials begin deciding which rulings to follow and which to resist, the entire framework of accountability weakens. Television panels filled with former prosecutors, constitutional scholars, and political strategists. The debate stretched across networks and online platforms. One side emphasized restraint. The other emphasized enforcement. Some analysts tried to step back from the heat of the moment. They pointed out that tensions between courts and public officials are not new. American history is filled with moments when branches of government clashed over the scope of their authority. Disputes over executive orders, battles over federal versus state power, conflicts over civil rights enforcement. Time and again, the courts have found themselves in the middle of controversial national debates. But many observers agreed on one thing. This moment felt different. It wasn't happening quietly in appellate briefs or academic discussions. It was unfolding in real time, in a packed courtroom with cameras waiting outside and millions watching from home. There was something personal about it. The exchange between Bondi and the judge wasn't abstract. It was direct, visible, immediate. Viewers could see the tone, the body language, the firmness in each statement. That visibility gave the confrontation emotional weight. For some watching, it felt like a courageous stand. For others, it felt like a dangerous escalation. And for many ordinary viewers, it raised deeper questions that went beyond one hearing.
How far can a court go before it crosses into policymaking? When does challenging authority become defying it? And what happens when neither side backs down? Those questions aren't easy, and they don't have simple answers. On talk shows and podcasts, experts debated the meaning of judicial independence. Some argued that strong courts are essential precisely because they can issue unpopular rulings without fear of political backlash. Others warned that unchecked judicial power can blur the separation of powers if not carefully restrained. The conversation spread beyond legal circles. Community leaders discussed it at town halls, university classrooms analyzed it in constitutional law courses. Even casual conversations at dinner tables began referencing the showdown. The case had become symbolic. For supporters, it symbolized the courage to question authority when boundaries seem unclear.
For critics, it symbolized the importance of defending institutional order even when disagreements arise. And hovering over all of it was one central reality. The public was watching. In past decades, many courtroom confrontations unfolded with limited visibility. But in the modern media landscape, moments like this travel instantly. Clips are shared. Quotes are dissected. Reactions multiply within minutes. That level of exposure amplifies everything. It raises the stakes for both sides. It intensifies public pressure. It turns legal arguments into national debates. Yet beneath the headlines and commentary, the core issue remained deeply structural. This was about power, not in a dramatic or theatrical sense, but in a constitutional one. Who defines the limits of authority? Who enforces those limits? And how does a system built on checks and balances handle open disagreement between its branches? As the day went on, one thing became clear. The courtroom confrontation was no longer just a legal dispute. It had become a mirror reflecting broader tensions about governance, accountability, and the meaning of institutional power. Some hoped the matter would cool down through the appeals process. Others anticipated further escalation. But no one doubted that the moment had left an impression. Because when questions of power and principle collide in public view, they don't fade quietly. They echo. And this echo was just beginning. The next move was crucial. After the judge's firm warning and the heavy silence that followed, the courtroom paused for a brief recess. Attorneys gathered in tight circles. Papers were reviewed again. Quiet conversations replaced public arguments. It was a moment of recalculation. When proceedings resumed, all eyes turned once more to Pam Bondi. She rose with the same composure she had carried throughout the hearing. There was no visible frustration, no dramatic gesture, but there was a noticeable shift in tone. While maintaining her legal objections, Bondi made it clear that her team would seek a formal review of the ruling rather than refuse compliance outright. It was a strategic pivot. Instead of escalating the confrontation into open defiance, she chose to channel the disagreement into the appeals process, the very mechanism designed to handle disputes over judicial authority. It was a move that signaled two things at once. She still disagreed strongly with the court's interpretation, but she would fight that battle within the system, not outside of it. The distinction mattered. By choosing appeal over refusal, Bondi reframed the conflict. What had felt moments earlier like a potential constitutional standoff now shifted into a structured legal contest. The battlefield moved from the immediate courtroom to the higher courts, where panels of judges could examine the arguments anew. The judge listened carefully as she outlined this decision. He gave a slight nod, subtle but unmistakable. His warning had landed. The authority of the court had been asserted, and the message had been received. There was no dramatic exchange. No raised voices, no sudden reversal. But the temperature in the room dropped. The immediate crisis cooled. What could have spiraled into sanctions or contempt proceedings instead transitioned into something more procedural, but no less significant. The legal dispute would continue, but now it would unfold through briefs, filings, and appellate arguments. Yet something had undeniably changed. The confrontation had forced both sides to articulate their positions clearly and publicly. Bondi had drawn attention to concerns about judicial reach and constitutional boundaries. The judge had reinforced the principle that court orders must carry enforceable authority. Both principles, restraint and enforcement, now stood in sharp focus. For observers, this was the real turning point. Not because someone won in that moment, but because the system itself had been tested and held. There was no dramatic arrest,
No explosive ending. No gavel slammed in fury. Instead, there was something quieter, and perhaps more powerful. A reaffirmation of process. In a system built on checks and balances, tension is inevitable. The executive branch and the judiciary will clash at times. Interpretations of authority will collide. Disagreements will grow heated. But the strength of the rule of law depends on one essential principle, that even the strongest disagreements are resolved through the legal framework itself. Appeals, reviews, higher courts, written opinions. That structure exists precisely for moments like this. By choosing to seek formal review, Bondi signaled that her challenge was not to the existence of judicial authority, but to its interpretation in this specific instance. And by acknowledging her decision, the judge signaled that disagreement, when channeled properly, does not weaken the system. It reinforces it. Outside the courthouse, reactions continued. Some supporters wished she had pushed harder. Some critics remained skeptical of her motives. But many legal observers noted the significance of the shift. What could have become a direct institutional clash instead became a constitutional dialogue.
And that dialogue would likely move upward, perhaps to appellate courts, possibly even further, where questions of jurisdiction, authority, and limits would be examined in even greater detail. But for those who had been inside that courtroom, the most important moment had already occurred. It was the moment when escalation seemed possible, and then wasn't chosen. That final warning from the judge, it wasn't simply directed at one official in one case. It was a reminder to everyone watching, inside the courtroom and across the country, that power in a democracy is never absolute. Courts have authority, elected officials have authority, but both operate within boundaries. When those boundaries are tested, the system does not rely on force. It relies on process. And process can be slow. It can be frustrating. It can be deeply contested. But it is what keeps disputes from becoming crises. As the hearing concluded and people began filing out of the courtroom, there was no applause, no dramatic finale, just quiet conversations and the hum of reporters preparing their next live updates. Yet the weight of what had occurred lingered. This was more than a courtroom dispute. It was a defining moment in the ongoing national conversation about authority, responsibility, and institutional strength. As the case moves forward, the larger questions remain. Who ultimately defines the limits of power? The courts, elected officials, or the Constitution itself, interpreted over time? The next ruling may bring clarity, or it may spark another debate, but one thing is certain. The balance of power is not self-sustaining. It survives because, even in moments of tension, leaders choose to fight their battles within the framework of the law. And in that choice lies the true turning point. If you enjoyed this courtroom story and want more real-life moments of tension, power, and unforgettable responses, make sure to like, share, and subscribe. And stay tuned for the next story.